this Glasginburgh conference. And I'm delighted to have 3 speakers here. Now, just to let you know that this session is being recorded. So I hope that you're all happy with that. So what I'll do is I'll introduce our first speaker, and then I'll introduce our second speaker, and then I'll introduce our third speaker. And each speaker will have 15 minutes, and I'll give them warning at 13 minutes. And then we'll open up for discussion, not too expansive in terms of comments, and hopefully some pointed questions to our speakers. And I very much look forward to the panel. So let me first introduce our first speaker, Professor Tilmann Altwicker. He is based at the Institute of International Law and Comparative Constitutional Law at the University of Zurich, where he writes extensively on human rights law, constitutional law, and international law. So I will hand it over to you, Tilmann. I'll turn off my microphone if everyone can make sure their microphones are off, and I'll let you know, Tilmann, when you are at 13 minutes. Thank you.
So thank you. Let me just set up the presentation. So many thanks to the organizers for having me in this exciting conference. And of course, I would have liked to be there in person with you. And I hope that this opportunity arises at another occasion. Now, what I would like to address here are a couple of questions concerning the overall theme of social justice and the judicial interpretation of international equal protection law. I don't think I can touch all of these questions, but let's see how it goes. So my first question is socioeconomic inequality within states a human rights problem? And the second is, are we heading towards a new global social question? And what's the role of law here? And then once again, should socioeconomic inequality within states be a human rights concern? And then I look at socioeconomic inequality and international human rights law in a bit in a closer fashion. And what's the state of play here? Does international human rights law have anything to say on socioeconomic inequality? What should governments do, very briefly? And then if I have the time, I will tell you some thoughts, some preliminary thoughts about a transnational perspective on socioeconomic inequality. Now, is socioeconomic inequality within states a human rights problem? And typically, I guess, you could distinguish 3 positions here. One, and I take just one name out of many here, is a skeptical position held prominently by Samuel Moyn, who says that socioeconomic inequality cannot be solved by human rights law. Historically, Moyn says the equalizing force was strong government's intervention, not a critique of governance, especially not a critique by courts. And then I take this to be a middle position held by Margot Salomon, whose talk I greatly admired, the keynote speech just now. And in an interesting piece, she talks about inequality not being a neutral force in the world, and I quote her here. And she has this position that I really found interesting, that she says that there should be a shift of a burden of proof to governments to show that gross inequalities are consistent with human rights. So this, I think, is a clever middle position that you can have on this sensitive issue here. And then we have Philip Alston, who is strongly in favor, and he says the international human rights framework is critical in addressing extreme inequality. And he points to negative effects of socioeconomic inequalities on equal opportunity, on biased regulation, and that it perpetuates gender discrimination among those wrongs or bads that are associated with socioeconomic inequality. Now, are we heading towards a new global social question? And I take this to be the rising gap between the haves and the have-nots. And if we can trust the economic literature, there is a pattern at least since the end of the 20th century, emerging that there is a falling inequality between countries, but a rising inequality within countries. For example, the US has the highest rate of income inequality among Western countries, and the tax cuts of 2017 have overwhelmingly benefited the wealthy and worsened inequality, according to a UN report. And here's, one widely used measure is the 19:10 ratio that takes the ratio of the income needed to rank among the 10 top percent of the earners in the US, the 19th percentile, and relates this to the income at the threshold of the bottom 10% owners, the 10th percentile. And whereas in 1980, the 90:10 ratio in the US stood at 9.1, meaning that households at the top had incomes about 9 times of the incomes of households at the bottom. This has dramatically increased after 1980, reaching 12.6 in 2018, an increase of 39%. And then you can compare these to other G7 countries, and you see that the US is constantly the worst in terms of socioeconomic inequality here. Now, what's the role of the law in all of this? And here I just take 2 very prominent publications, but they seem to converge, in my view, that the law plays quite a negative role in socioeconomic inequality, and we've heard this just before in the keynote speech by Margaret Salomon. And here I take Joseph Stiglitz, who says that the regulation of the economy has, of course, distributive consequences that favor some, disfavors others. And in the US, typically the top layer are enriched at the expense of others. And similarly, in a recent work, Katharina Pistor has claimed that the law serves the interest of the wealthy and perpetuates inequalities. Now, let's take once again this question: should socioeconomic inequality within states be a human rights concern? And here you could point to certain values that are protected when we protect socioeconomic equality. One, the concrete individual freedom. When we talk about autonomy and self-realization that are so much at the heart of civil and political rights, there is a fair claim to be made that, that these rights depend on socioeconomic conditions. Now, I would extend that argument and say that in today's digital world, knowing how to read and write will soon not be enough. We I think it is imperative to educate our students and the rest and the citizens in digital skills like programming. In the future, concrete individual freedom will depend on education much more than it has ever before, I think. So concrete individual freedom is depending on skills and on equality in order to be practical and effective. Second, social inclusion. Socioeconomic inequalities are often accompanied by inequalities of social status that encourage those of lower status to be viewed by themselves and by others as inferior. And this leads to serious evils, as John Rawls has prominently claimed in one of his works. And then third, political stability. We see several empirical studies that now show that there are strong or significant correlations between socioeconomic inequality and social unrest. And in times of datafication of everything, we will soon be able to know much more about these associations between socioeconomic inequalities and important constitutional values such as democracy and political stability. So my answer to this question would be, yes, socioeconomic inequality within states should be a human rights concern. If we want to talk about meaningful freedom and a livable life, protected for centuries by human rights, we must also talk about socioeconomic inequality. Now, what about international law and international human rights law in particular? And I focus even more closely on international equal protection norms. So what can we say about international equal protection law in that respect? Does international equal protection law care about the unequal distribution of socioeconomic goods within the state? So that's always my focus, that it's the inequality within the state. Now we have very few sectoral norms in international equal protection law. One would be the equal pay of men and women for equal work in the European Social Charter, but not much more. Other than that, we would have to look into the general covenants here. So I took for my analysis the International Covenant on Economic, Social, and Cultural Rights, the ICCPR, the Inter-American Convention, the European Convention. Now, interestingly enough, the Committee on Economic, Social, and Cultural Rights has no decisions. I didn't find any decisions concerning socioeconomic inequality, and this surprised me when I first encountered this. The UN Human Rights Committee has one case. Probably will not pronounce this correctly. Siobhan Whelan versus Ireland from 2017, where the committee says that socioeconomic circumstances relating to the termination of a non-viable pregnancy were taken into account in the reasoning. The more interesting cases come from the Inter-American Court, and really, my view is that the Inter-American Court is in the lead, is currently in the lead of developing a jurisprudence on socioeconomic inequality. Let's take two cases: Gonzalez Luis versus Ecuador from 2015. Very sad case. Talia, a minor, was tested positive for HIV. And she had been given multiple contaminated blood transfusions. She suffered from discrimination both by school officials, teachers, and also by the landlords, and her family was evicted several times. Now, the Inter-American Court found this to be a violation of non-discrimination, Article 1.1, in respect of the right of education. And here, the Inter-American Court was very clear that Talia, the young girl, was very vulnerable, had a vulnerable status, and that's important. The court mentions the socioeconomic status as a ground of discrimination that is contained in the convention text, and here the court activated precisely that status. Even more interesting from a legal perspective, from a doctrinal perspective, is the case of the fireworkers factory in Santo Antonio versus Brazil from 2020. Here, Brazil's responsibility for events relating to an explosion in the fireworks factory was at issue. 60 people died in the event, and the court repudiated Brazil for having remained passive in the face of a situation of structural poverty of these workers. The state had failed to set up governmental programs to change that situation. And the court relied here on Article 24, equal protection, and it said that the state had an obligation to correct existing inequalities, unrelating to existing programs. So here, an original obligation to provide individuals with the real possibility of achieving material inequality was first found, and in my research have not come across a case of similar clarity regarding an original right to socioeconomic inequality under international human rights law. Now, the situation looks a bit less optimistic when you look into the European...
2 minutes. Sorry, Tilmann, 2 minutes.
Okay. Into the European situation there, we have one case where the court actually missed an opportunity to pronounce on socioeconomic inequality. That was Garib versus Netherlands. This case concerned a housing permit in Rotterdam, which was withheld due to the unemployment status of a woman. And here the court simply missed the opportunity to pronounce on socioeconomic discrimination for the for the first time. Now, I cannot go into the doctrinal problems that are associated with socioeconomic inequality for real. Just take note maybe that we're talking about, often we'll be talking about indirect discrimination, and the question really is there a positive obligation to provide for socioeconomic goods under international law? Now, I should probably finish here. With my talk, I have tried to argue that socioeconomic inequality is indeed a human rights concern, and that that given the rise in empirical research on this topic, I think we will soon know much more about the real preconditions of our freedoms when we protect civil and political rights. Inequality within countries has certainly become an international concern, and the engagement with international human rights courts with socioeconomic inequality is, in my view, a welcome first step to address those problems. Thank you very much.
Thank you very much, Tilmann. Thank you, and also for keeping to time. I'd like now to call on our second speaker, Luciano Bottini Filho, who is a PhD student at the University of Bristol Law School, and there he focuses on issues relating to health and human rights. So take it away, please, Luciano. Thank you.
Hi, hello everyone. Thanks for having me. I just want to share my screen here. Yeah, that's the thing that's happening. Share. No, that's not the one. Are you seeing my screen?
Yes.
Yes. Yeah.
Thank you.
The slides, because just went to.
We can see the slides.
Okay, so here we go. I work with global health law, the right to health, and resource allocation. Yeah, and what I'm going to talking about is how law relates to scarcity and how scarcity creates inequality. Yeah, the infrastructure that quite make challenging allocate resources around the world and set priorities to achieve the right to health. So what I'll be talking about is how to read international human rights law to challenge scarcity. Yeah, we've been through the pandemic, yeah, and rationing and insufficient resources to tackle. Yeah, now we're talking about vaccines, but before we were talking about ventilators, hospital beds, yeah, and in socioeconomic rights, this is very important, yeah, because socioeconomic rights are dependent on progressive realization and available resources. Yeah, so what I was trying to do is how do we read international law so we challenge scarcity, and how we set priorities, because the right to health implies loads of obligations. Yeah, well, how every country lives in a different circumstance. So how we set priorities, how we should navigate international human rights framework to contest scarcity, so we can realize rights. Yeah, and I'm going to talk about three approaches, and I'm about to defend the first one. So when we talk about resource allocation health, yeah, and when we talk about health and human rights movements and international law and global health lawyers, we tend to go towards a procedural approach. Yeah, and that's not because the law states such. International law does not provide for such framework. But when we talk about resource allocation, there's a lot of influence of public health ethics, especially from normal Danues. So it's a framework to how we deal with scarce resources in a healthcare setting. Yeah, and it's been used during the pandemic as well. So instead of defining what we have to provide for every patient or every person in the world, what we should do is create a fair procedure, and we accept the scarcity as it is, because scarcity is unavoidable, and then we create a democratic deliberation. So as long as you have these four criteria that you can see on your screen. Relevant, so we identified what is the criteria to allocate resources. Yeah, and that's really hard to achieve, because you need fair-minded people that are without any interest to agree on what is the criteria, and patients are very different, and medical doctors and governments have different interests, so it's really hard to achieve. Publicity, so it has to be an open process. Revision and appeal, so if there's new evidence or the new circumstances, you can revisit the decision. And enforcement of this development, once you achieve deliberation, you have to enforce it. Yeah, so for many health and human rights lawyers that they publish everywhere, they would align to this view that you don't have actually a right to health, you have the right to a fair share of the budget. But the thing is, if your budget is really small, then your right to health is small as well. Yeah, and different countries have a different budget. So actually, it's not a problem that the circumstances go against your budget. The problem is that you don't spend very well, and you don't have a fair procedure to achieve this budget. And most of this view follows the empirical findings that have been done on litigation in South America, where, and it's very controversial because you have different samples of that, but what many, and you can see in the graphics, the number of lawsuits on the right to health. So in countries like Brazil, where the right to health is judiciable, people who has access to lawyers, they request expensive medication, and that distorts the budget. So it's not fair to have a claimable right to health. What is fair is if you got a fair procedure. Yeah. Under international law and international global health governance, this idea of having institutions that allocate resources permeates international cooperation. So we have a lot of partnerships in health technology assessment, which is, like NICE here in the UK, is a body that structures the local priorities. Yeah, where are you going to allocate resources? So if you see those big NGOs and global health partners, they go to different countries, and what they say is, well, it's not that you have a market failure. It's not because the medicines are too expensive. You just don't spend very well. Yeah, so you need to be a better buyer, you need to implement health technology assessment, and you need to decide what you're going to spend so you can achieve universal health coverage. Yeah, and this has been the discourse in global health. So how we deal with scarcity. So and how you ground these policies, yeah, that goes beyond a procedural approach when you implement a health system, when you try to achieve the right to health. So in my view, if you draw on the International Covenant on Economic, Social, and Cultural Rights, you should focus on substantive principles and not only procedural principles. And that's go towards maximum availability of resources and progressive realization. And that's key to deal with scarcity. Yeah, instead of getting thinking about how we're going to divide the cake, how can we grow the cake so we avoid these difficult choices. Yeah, because even, and I can discuss this later, but it's really hard to identify. The human nature is really hard to make those tough choices. Yeah, so this is the framework that I've been working on. So a problem with the right to health is that what health advocates do is they identify priorities, yeah, under international law. So after the pandemic, a lot of people jumped the bandwagon of coronavirus. So everything was a right to health violation. So if you're working on reproductive rights, you would say, oh, we got to provide this because reproductive rights are important. And then you have a set of obligations, yeah, and then you arrive at scarcity because you can't fulfill those obligations that you frame as a human right. And and the problem is, in every different part of the world, you have a different set of priorities. Yeah. So for example, in epidemic control, many human rights lawyers were interested in how you tackle airborne disease. But if you go to the global south, where you have mosquito transmitted disease, that's a different strategy. So you can't frame things that you learned during the pandemic as a priority for the rest of the world forever. Yeah. And what happens is the monitoring system tend to focus too much on obligations of results. So you gotta achieve maternal health. You gotta vaccination for all children, yeah, and not obligations of conduct. So it's a really bad feedback, the international monitoring system, because they just dump loads of obligations and don't focus on the conducts to achieve those obligations. Yeah, and those state conducts that are steps towards the results are not discussed on international law. So we don't know what is and an optional protocol to the international covenant applies the reasonableness doctrine, which is the standard of review of whether you are fulfilling your obligations. So we don't know what's reasonable in terms of state conducts to maximize resources, yeah, to achieve progressive realization. And then we have a process that everyone is a human rights violator from obligations that are not defined locally. So what it's the best strategy is to identify, the goals of the right to health in a certain country, yeah, and that's of course through participation, and focus on whether they are implementing, yeah, whether they're doing the right conduct to achieve this result, yeah. I won't stay long in this, but essentially my framework is like this. So we have to stop identifying violations of the right to health in state conducts that can avoid scarcity and can achieve the results we want that are locally needed. So I'm just, it could be applicable to any socioeconomic right. I'm just presenting some access policies that are related to pharmaceutical products, but you can do price negotiation. There are countries that it's unlawful to negotiate prices with pharmaceutical countries, such as the United States. You have managed entry agreements, so it's procurement strategies to lower prices. You have pooled procurement, so that's that's a nod to Margaret, international cooperation. Yeah, you have a contract transparency. Most of the literature states only intellectual property, but it's really rarely effective. So there is a poor awareness of the strategies we can use to avoid scarcity, because even if you do compulsory license, you don't have the price can be high. Yeah, so there's something called the generic paradox. And yeah, I will skip. So the second approach, which, if you're a country and you want to know where you're gonna, what you're going to do as a right to health obligation, yeah, and how you prioritize your resources. The second approach is if you draw on the Committee on Economic and Cultural Rights, and you establish a hierarchy of obligations. So if you're about to set up a health system, yeah, and that's the obligations under the international, the General Comment 14, you would accept there are core obligations, yeah. So and those core obligations should receive higher priority. And so if you have low resources, you could just just prioritize what are core obligations. Yeah, so it's very disputed, the nature of core obligations. I don't want to discuss this now, but so if you talk with Kate Young, she would say that they are not enforceable. If you talk with Tassiolas, he would say they are. So and it is kind of soft law. So and the problem with this core obligations, if you say, well, states have to first fulfill those core obligations, they quite doesn't fit to new events like the pandemic. Yeah, so and they are quite ambiguous so as well. So we have also, when Paul Hunt wrote the comment, he set core obligations and also obligations of comparable priority, but we don't know what it means. And communicable diseases and epidemics are in comparable priority. So many countries, if they were trying to fulfill their core obligations, they shouldn't be prepared for a pandemic so far. So it's quite tricky, and it's very rigid. Yeah. An expensive approach is something that's happening now, and it's something that creates a lot of confusion in how we fulfill the right to health. So the expensive approach is getting, essentially, is this new buzzword called global health law. It has been talked for long in India, but since Gosling published a book, now we know what it is. Because,
2 minutes, Luciano. Thank you. 2 minutes, thanks.
And the idea is, and many human rights lawyers, so we have the Sustainable Development Goals, yeah? So every single document that relates to the right to health can be seen as a priority where we have to achieve. So you got all these targets from the Sustainable Development Goals. So under global health law, under the system of governance, yeah, different soft law instruments reflect the right to health. And that's confusing because some of those goals, if you see that it's a paper from Waite, the resources are overlapping, so you can't really identify priorities in the Sustainable Development Goals. And some of the Sustainable Development Goals don't reflect core obligations, yeah? And many human rights lawyers are reading the Sustainable Development Goals as expression of the right to health, or whether they can be monitored as the right to health. And many of the Sustainable Development Goals, either they have gender problems, they don't follow some principles that are core obligations, and most of all, they wouldn't fit the local priorities. Yeah. So this is a little graph where you would find core obligations, where we found SDGs. So sometimes when you achieve a core obligation, you are not achieving a SDG. I will skip this one. And so why the minimalist approach is good? I think most of all, when we just set a large wish list of what we want to achieve and what we want, you render every state of rights violator. Yeah, and it's not a constructive approach. It's a really bad feedback. What we do with this, we impose obligations that may be disconnected with the local reality, with the local priorities, and we want to enforce them without showing a way to fight scarcity. Yeah. So and the more we grow with all this human rights language in all the soft law instruments, the more confusing it is to identify what we should achieve with the right to health. So I think we should step back and try to identify more substantive principles to maximize resources, yeah, and achieve what we need to achieve in every single state, yeah, which might not be the same everywhere in the world. It might be not the same at a different times, as we see now in the pandemic. So thank you.
Thank you very much, Luciano, also for keeping to time. Thanks very much. We now turn to our third speaker, Nicola Soekoe. Nicola is based in South Africa, and there she currently is a socioeconomic rights researcher, where she works with two organizations one is called the Mining Affected Communities United in Action, and the other entity is Women Affected by Mining United in Action, both based in South Africa. So thanks very much, Nicola. I'll hand it over to you.
Well, thank you so much. I'm really happy to be here. And despite the conference being postponed, the paper has changed so much, and it's actually ideas now that are relatively new to me. And so I'm really eager to hear if there's any, if I'm on the wrong track or there's any feedback. So my paper is looking at international investment law. The greater symmetry of international investment law is now widely acknowledged. Primarily because of the mechanism that allows foreign investors to sue host states when they regulate for the public benefit, for the public interest, and that regulation, in essence, infringes the expected profits or other aspects. And so in response to this now widely acknowledged greater symmetry and there have been many proposals for reform. So some of those proposals have just been the inclusion of explicit provisions that are broadly defined around sustainable development. So those could be around creating room for the state to regulate, to protect the environment, to protect human rights, to prevent corruption, and essentially preserving states' right to regulate for the public interest. There's also developments that curtail the use of international arbitration or international investor-state dispute settlements. And the belief is that by curtailing the use of international arbitration, you also reduce the risk of regulatory chill. States will feel more comfortable to regulate for the public interest, as there's not as great a risk of arbitration. And then there's some other interventions as well, such as allowing more involvement of third parties when arbitration does arise, and a few other changes. And these are often grouped in terms of new generation investment agreements. Obviously, the success of these interventions is difficult to measure. Once an investment agreement is signed, it takes long before there's an investment, it takes long before then there is a conflict, and then potentially an arbitration to actually be able to test whether the inclusion of these changes, and I'm going to focus specifically on sustainable development provisions, whether the inclusion of these provisions actually leads to the public interest being protected more. And I'll focus specifically on Indigenous and peasant communities, and whether it results in them essentially having more power in this very unequal system. And so, you could imagine ways that you would test whether this inclusion is working would be to look whether corporations now feel compelled to comply with environmental and social expectations because of the provisions of the investment agreement, or when they don't comply and the state regulates as a result, whether they are more hesitant to launch an arbitration case, or if they do launch an arbitration case, if they then are less often successful because of the provisions in the investment agreement. You could also look at cases where communities do raise their voice, do make demands on the government, and see whether that results in either arbitration or whether it results in the state violently squashing protests because of the fear of arbitration. So all of these ways to kind of test whether the inclusion of sustainable development provisions does any work for communities, we can't really do now. There just isn't sufficient body of case law. And so what I would like to, but in the interim, there is a lot of energy and commitment being put to including these provisions in investment agreements, the assumption being that they ultimately will lead to better results. They can't do much harm. So what I would like to do is focus specifically on one arbitral award, the Bear Creek versus Peru award, to see whether the inclusion of sustainable development provisions in that investment agreement did lead to community grievances being better accounted for when arbitration arose. And so the questions asking are really like, what work do the sustainable development provisions do in protecting the Aymaran community that was at the center of the dispute? And did the presence of sustainable development provisions compel the arbitrators to consider the community's grievances in a way that they otherwise may not have? So a little bit of background into the case. It's quite a widely known one. I think a lot of people in the metaphorical room may know about it. From what I can tell, it is the only case or arbitration case that has been concluded where investment agreement with comparatively robust sustainable development provisions was the subject of an arbitration that dealt with community conflict. I can tell you in question and answer how I got to that determination if you're interested. I can't summarize the whole case, but essentially a Canadian investor who had a mine, Santa Ana mine, they had conducted community consultations, but not with a wide enough group. But for whatever reason, there was a mass upset, mass revolt against this mining project. And the grievances were expressed intentionally and very clearly in the language of Aymaran philosophy and Aymaran thinking. So there was a lot of discussion about the integrity of the territory and preserving that, and of specific sacred places. And so ultimately, the unrest escalated, there was a lot of loss of life, and the Peruvian government felt compelled to essentially release a decree that would cancel both that mining project and any mining projects in the area. After it did so, the unrest did stop, but ultimately Bear Creek did take the Peruvian government to international arbitration, and it was found that that action was considered indirect expropriation, worthy of compensation. So, one second. So obviously when you're trying to look, you're reading these dozens of awards and you're trying to look at whether they, or how community grievances or community perspectives were considered, if at all, by arbitrators, you're looking for kind of a phrase that says a statement like, we don't care about community perspectives, but you never find that. In fact, what you find is that the conflict you've been following in media, following reporting on protests, following activists you know who may have been involved, is almost indistinguishable from the conflict you see being discussed in the arbitral award. And so instead of saying, well, okay, obviously the subject of the protest wasn't a legal problem, I think we're instead called to ask, what is it about international investment laws, foundation, structure, and ideological commitments that render it so impenetrable to considering the issues that affect communities in their own words? And then asking, does the inclusion of sustainable development provisions into investment agreements change this, make it more porous to those other perspectives? And so in asking this, I've been helped along by other scholars who have asked these same questions, but for different frameworks, such as human rights or international law more broadly, or development as a concept. So I've read a lot of Mario Blesa, Cristina Rojas, Arturo Escobar, Marisol de la Cadena. And what those scholars have essentially challenged me to do is to look at the coloniality of international investment law. Coloniality is defined by Nelson Maldonado Torres as a corollary of modernity, and it's the enduring logic, metaphysics, ontology, and matrix of power that flow from colonialism. Coloniality has a universal and universalizing ontology, so essentially what some people call the one world, that posits a universal conception of what the world is, and therefore posits universal solutions. Some features of coloniality and this ontology of coloniality are both a nature-culture divide, nature being the way things are, culture being our perspective on the way things are, colonial divide, the divide between what Santos would call the abyssal line, but what Blesa would call moderns and non-moderns. And the abyssal line basically separates metropolitan societies, sociabilities, and ways of being from the colonial other. And a key feature of moderns, if we'll follow Blase's term, is that they have knowledge being the ability to distinguish between reality out there and then our perspectives on reality. And then another key feature of coloniality would be linear conceptions of time. And I just want to quote Escobar, where he says, modernity coloniality assumes the right to be the world, subjecting all other worlds to its own terms, or worse, to non-existence. And so these scholars would argue that the incorporation of sustainable development into investment agreements is unlikely to provide enhanced protection to communities that are bearing the brunt of foreign investment if its incorporation still relies on an ontology of coloniality that renders other life worlds invisible and therefore incapable of being protected. So what I've done, and I won't be able to go into my full analysis, is done a close reading of the arbitral award and the various other submissions to see whether I can, to conduct essentially a political ontology of the award. And there's some really interesting features of the award. So the one is the discussion of whether what the Peruvian state did qualified as expropriation. One of the additions into the Canada-Peru Free Trade Agreement was this exceptions clause. The exceptions clause essentially said nothing in this agreement will prevent a state from or party from adopting or enforcing measures necessary to protect human, animal, and plant life or health, which includes environmental measures, or to conserve living or non-living exhaustible natural resources. So this is one of, this is seen as kind of quite a progressive incorporation of these foci, right? So plant health, human health, and animal health. And so this Peruvian state essentially argued what we did was not expropriation because it falls under these exception clauses. It was necessary to preserve these types of life. What the arbitrators and what the panel decided essentially is that this list is exhaustive, which means anything that any of the motivations for the type of regulation that the Peruvian state did has to fall explicitly within these things. So explicitly protecting human life, animal life, plant life, explicitly conserving either living or non-living exhaustible natural resources. And the decree that the Peruvian state released when it did cancel all these mining rights didn't explicitly mention one of these things. It just said circumstances, really, the circumstances that have developed. So the tribunal said, look, it doesn't seem like this is an exhaustive list. It doesn't seem like it falls into this. But even if it does fall into this, this exception clause is not a police powers exception. So police powers essentially allows the state to regulate for the public interest, and it negates the existence of an expropriation. Because this investment agreement had an exceptions clause, it said the police powers doctrine won't apply. And because this exception clause doesn't mention anything about regulation under this clause not being expropriation, it's still expropriation. So one wonders then what's the purpose of an exception clause if it still counts as any expropriation. But for my analysis, what you see is both the need to capitulate into this ontology of coloniality when expressing what the unrest was about, including things like the only things being worth protecting being exhaustible natural resources, and then distinguishing between whether what was being harmed was human, animal, or plant life or health. And so you see that, and then you also see
Please.
2 minutes, yeah, sure. And you also see, just the voice, the very kind of really extensive expressions of what exactly the fight was about, being completely ignored and non-existent. And so there's many places where you see this throughout the award. Another place is when the discussion of the culpability of Bear Creek. And ultimately, the tribunal found that, look, they could have done more in terms of their relations with the community, but they did enough. And really, they agreed with Bear Creek's determinations of what was realistic. What's a realistic expectation for us to do? And again, it was here you really saw this idea between moderns and non-moderns, and the idea of who has the knowledge to be able to determine what's realistic and what is real versus what is a belief system and ideology that doesn't have practical import. And so you see this, another place you see this is when a key feature for why they said the Bear Creek did enough is that they say the state knew about the steps they were taking to consult communities and it agreed to that. And so the assumption is that the state is a legitimate and in fact the only legitimate political representation of moderns, and that the other political formations that did not know and were very much against do not hold valid knowledge or perspective. To end off, I just want to read a quote from Blazer, which I forgot to read earlier, where he says, "Can you imagine a politician or a corporation stopping a profitable mega development because the natives say a spirit or an ancestor does not want it? The reasonableness of the demands will depend on the degree to which they are aligned with reality out there. In other words, the test question that will be posed to these demands will be whether they are grounded in reality or not." And so that's, to conclude, I couldn't give all of my kind of close analysis, but to conclude, that really shows the motivation for conducting a political ontology analysis of this very limited case law that exists to understand the limitations of including sustainable development provisions in investment agreements. Thank you.
Thank you very much, Nicola. Well, now it's time, hopefully, for some questions and feedback and comments from anyone out there. If you'd like to ask a question, please just raise your hand in some form. Hopefully, I'll note it. And then, I'll call on you, please. Well, if people are still thinking, I just have a few questions. And for our speakers, thanks. I mean, I found it a great panel. So firstly, I just have a question or two for Tilmann. Tilmann, do you have a sense as to why you think that there is more attention now being paid to this question of inequality within states? Is it simply that, well, we have more inequality than we did before, and so it's on the radar, or do you actually see that there's some sort of intellectual shift taking place, and that that's somehow also then permeating to debates within the human rights scholarship? And do you think it's actually going to be a significant shift than we see in that scholarship? I mean, it seems like you're sort of tracking this new development, but yeah, do you see much potential, I suppose? And to what extent do you think that this notion of inequality that you're trying to ground in equal protection law is often also understood in relation to the achievement of civil and political rights? Obviously, you know, you focused on equal protection, but obviously one aspect of international human rights law is always the extent to which we treat rights as distinct and specific, or how we might understand them more holistically. So do you think it's better to take a very specific look at, for example, equal protection and think about inequality that way? Or politically, do you think it's valid also to think about it in broader terms, for example, through civil and political rights? So they're my questions for Tilmann. For Luciano, a very simple question. I mean, how do we understand health? And how do we, I mean, just really simply, how could we even define that? I think what the pandemic has shown us is that, okay, obviously we can understand something about health through, you know, access to a doctor or care or vaccine or ventilator, as you mentioned. But I mean, I think what we've seen with the profoundly unequal effects, going back to Tilmann, from the pandemic has been the way that health is just so crazily related to everything in our lives. And that if you do come from a lower socioeconomic background, then your health is always going to be more fragile, let's say, than some others right from the beginning, so that by the time you do get to hospital, you know, you are already in a very different position to someone else. So does a right to health based on an expansive reading of scarcity basically ask for us to do a total rethink of social inequality before the point of health treatment? It's just, in some ways, what I'm suggesting is that in some ways the right to health should inform all sort of approaches to either human rights or just, well, governance more generally. So yeah, how might we go about thinking about that? And do you think that a human rights reading of the right to health is a useful political tool, for example, that people in the global south today who have not received a similar share to others in the global north, vis-a-vis even, for example, vaccines today, do you think that a human rights framework in terms of the right to health would be a useful political tool for them to realise that and to sort of counter some of the inequalities that we're witnessing? So just a few questions there. And thanks Nicola as well to your really detailed account of this case, which I was not familiar with, but it does sound fantastic. So I just wanted to push you on the political ontology idea, and just, you know, really simply for someone who doesn't know anything about this, can you just talk us through what your methodology entails when you pick up this case? I mean, as law students, we know how to read a case in terms of doctrine, and, you know, we could look at the treaty or the arbitral agreement or whatever else, but what is it that's different than when we adopt this methodology of political ontology? And do you think that is a particular methodology related to the decolonial scholarship that you're relying on, or could you sort of suggest perhaps other bodies of literature where this methodology of political ontology is also employed, you know. So for example, not that they would use it, but would feminist readings of the case, for example, also give us some type of different political ontology here as well? And I think I'll just leave my questions there because I can already see some hands. So if we, are you happy for me to gather some more questions, or would you, yeah? Okay, so I think I can see Gail, if you'd like to ask a question. Thank you.
Yeah, thank you so much for your papers. I think my main question maybe is for Tilmann, and I think it's amazing, or at least, or maybe we actually shouldn't be surprised that income inequality has been increasing in this age of human rights. But at the same time, giving critiques of human rights is maybe hardly surprising that we are actually seeing this rise in income inequality and just how stark the increases are. We're fascinating, so thank you so much for that presentation. But thinking about the structure of the human rights system, I was wondering about the socioeconomic inequalities that are starting to emerge between states, because the human rights framework is very much trying to address domestic socioeconomic rights, civil political rights, etc. And I wondered about if you might be able to say a few more words about socioeconomic inequality, or kind of in between states as well as within states.
Thanks, Gail. And if I can now call on Anna for her question. Thank you.
Hey, thanks, Michelle. So thanks also for the fantastic panels. I really enjoyed them. My question is really mainly for Luciano, although I think it intersects a little bit with what Tilmann was talking about, but it's really a clarificatory question. So I really enjoyed, I particularly enjoyed your visualization of the sort of procedural dimension of the right to health. I thought that was really interesting. And as I understand your argument, you were making a distinction between a procedural minimalist approach to the right to health and the core obligations approach, and perhaps a more maximalist, shall we say, tendency. But one thing I wasn't a little bit sure on was how you were thinking about scarcity, because at some point you seem to be suggesting with your analysis that scarcity is in like legally constructed through the market, and you mentioned various ways such as procurement in which scarcity would be constructed. But then at another point, you seem to be working with an idea that there is a hard budgetary constraint for certain states around the right to health, because you were talking sometimes about some states having the resources and some states not having the resources. And I suppose my question for clarification is really whether you think that that question of the budget, just as scarcity is legally constructed, the question of the budget is also, when we think in these terms of the market. And so perhaps if we have the right to health embedded in the Constitution, then we need some kind of constitutional overview or oversight of the whole exercise of the budget, if we accept, as I think you argued that we do, that something like the budget would be constructed in the same way that scarcity is. Sorry if that was a little bit long-winded. Thanks.
Thanks very much, Anna. Well, maybe if I could ask Tilmann first to have a response. Thank you.
Yeah, thank you very much for these excellent and probing questions. I won't do justice to them all. So the first question by Michelle was, why now? I would always argue that human rights law is and actually needs to be an answer to real problems. So I would always look into the real world and try to analyze the real world and see whether there is a real problem. And I think there is. It has been identified by economists to be a real problem, that these gaps between the have-nots and the haves are rising all over the globe. So my first answer would be yes. I think we all know, and we can all know, that there is a problem, and that was my first take. The second, I would say that the criticism of international human rights law as it stands has become more fashionable. So whereas the human rights community tended to be a circle that was praising itself for being so great and standing on the right side of life. Now people have become within the community more critical of themselves, rightly so. I think we now know that there are blind spots that have not been taken seriously. We now know that Enlightenment philosophy is great, but it's probably not the end of it. We now know that we need to think about social questions more deeply than we did before. We now know that there are intersections that we didn't know about before. And then third, there is, I think, a growing dissatisfaction with international human rights law that also propels into the outer orbit, or what has been the outer orbit of international human rights law, and that's precisely the social dimension of human rights law. And I would say that these three elements, to me, make it plausible that we see this trend, I think. Now, the other question was on the relationship between civil and political rights and equality. Now, there is a debate on whether equality is a value in itself, or whether we need to bring in the old values of that I also outlined, freedom of the individual, political stability, and all that. So I have made this claim that we can analyze, and we probably should analyze, equality from that angle, even though the discussion has not been settled. I think that, and to ask whether equality is a value in itself, I think some statements can still be made, even though speaking for myself, I would rather opt for going and arguing that we are essentially protecting the values that we know we protect when we protect civil and political rights. But that's a very deep discussion, and probably interesting to have. The third, I will skip the question on scholarship. For reasons of time, and to take the question by Gail, what you asked about equality between states, or inequality between states, that goes into the direction of what I would call the transnational perspective on socioeconomic inequality. And I would be interested in the role of international courts in that regard. So if I address this question, I would ask myself, do international human rights courts have instruments and the power and the legitimacy to tackle that question? The European Human Rights Court is very hesitant to develop this perspective. And then the question is whether we as scholars can develop that perspective on the basis of an evolving jurisprudence. And I think that's what I would do. I would look into an evolving jurisprudence and trying to systematize the individual judgments, and trying to come up with trends within the jurisprudence that bring to life this transnational perspective on socio-economic issues. I would not claim that the court would do that itself, probably not, but it's, I think, our task as scholars to develop that transnational perspective. I leave it at that. Thank you.
Thanks very much, Tilmann. And now Luciano, please.
Done. Sorry. Thank you for the question. So Michelle started with a very philosophical one, which what's the right to health? What's the content of the right to health? Yeah, and one thing that, if you go towards a procedure with some substantive elements, yeah, resource mobilization, non-discrimination, you have to identify what are your priorities locally, and you can identify what's needed as health. Yeah. So, but if you go towards the bioethicists and philosophers, they might have different approaches, and depending what approach you take towards health, that affects on international governance as well. Yeah. So the way we calculate the burden of disease, yeah, kind of discriminates disabled people, because you assume that someone who is on a wheelchair or is blind does not have the same quality of health as someone who is not, so their lives count less. So it's a very important thing that we as human rights lawyers discuss how we define health, but that has to be including the populations that affect. So when you talk about my health, I have to tell my experience, because I'm able to say what is my quality of life. So most of the international instruments that measure health, yeah, they might be discriminatory, yeah, but I can't stand myself in this discussion, but just to try to give you an answer. Yeah, I think it's an open question, but it needs the local involvement, and you cannot exclude the affected population to define what's health. And especially, and you mentioned the social determinants of health, yeah, how everything is interrelated, and that's very strong. That's something nice we picked up from the public health people. Yeah, we got in the UK, this is very strong, how rights are interdependent, yeah, and it's difficult, to prioritize. It's something that we have to think more, yeah. So in terms of what we're going to invest, if it is important for us, so we should invest on treatment and allocate resources to preventive or to income, because that will benefit the health of individuals. So we still don't have answers, not even ethically, and we don't have human rights standards for that, but we need to touch upon this. The other question was whether the right to health works. It did during the pandemic. Yeah, the problem is that people abroad, like in the global north, can't read in Portuguese, Spanish, or French, so they don't have access to the recent jurisprudence. I'm hoping with some projects that are going now in the UK, they start translating this, but it's not really accessible. But for example, in the Supreme Court in Brazil, there were Brazil is having a very conservative, now liberal government, yeah, attacking minorities. So indigenous people went to courts. They managed to get some protection, yeah, specific, because they are more vulnerable to the virus, because we have 100 tribes, 1 million people there. They are more susceptible to the virus. They managed to get cordon sanitaire, blocking their areas through the courts. We have after this descendants, we have gig workers, yeah, all that claim the right to health during the pandemic, yeah, and that happens in many places. So, and moving to the last question, yeah, Anna. So let me see if I got it right. So what you're asking me is that the question of budget, yeah. The thing, well, I know you work with political economy. If you think about budget as the way you have your budget in your house, yeah, that's limited. But if you think about budget as a government, yeah, scarcity is artificial, yeah. And another thing you have to think about is what we're talking about. So if you need more doctors, yeah, if you have more money, there's nothing you can do. You need more doctors. You have only 100 doctors. Yeah, you need a time to create more doctors. You have to bring it from somewhere. That's tangible scarcity. But there are scarcity that you can fix in a snap. Yeah, because of excessive prices. Yeah, anti-competition. Yeah, so that's artificial scarcity. Yeah, we have to distinguish those things. Generally, most of the times, yeah, it's artificial scarcity, and you can play with the budget. So it seems like when you talk about the pandemic, we forgot everything that we learned on the crisis, on the financial crisis, because if you talk with people from housing or socioeconomic rights more broadly, they would have a more expansive notion of what is resources and what the budget can do. Yeah, and that's something we learned from the European crisis. Yeah, and we have some standards in this regard. Just not to take long, just because she asked me what's my first approach. So there are procedural elements, yeah, but they are substantiated by human rights principles. Yeah, so you define your target. Yeah, you define locally what's your priority, and then and once you define your priority, you identify what's your steps, what you have to do to reach that priority. If you have scarcity and it's unavoidable, you can't deny the existence of that priority. Yeah, what happened in many countries when they raise the mantra of scarcity is that, oh, we don't have money, and then you don't have the obligation, because socioeconomic rights are dependent on resources. But what we have to do is invert. So yes, we don't have the resources. So what are the policies? And we have to press for those policies. Yeah, we do just recognize a violation and don't go towards the process to achieve, to implement the obligations. I hope it was clear, but.
Thanks very much, Luciano. And now Nicola, please.
Sure. So I actually had a whole section on methodology that was kind of cut out because of time. But before I quickly explain how this method I've understood it, rather let's ask the question, why not look at epistemology instead of ontology? And Mario Blaise makes a really convincing case by looking at environmental conflicts that although alternative views and like indigenous perspectives on things are more readily recognized now and internationally, these perspectives are too easily reduced to perspectives, cultural perspectives on the world that exists, and the world that exists remains unquestioned. And so, you know, it's cute that they think that this mountain has feelings. It doesn't though, and we need to mine here. So he basically says that as a tactic when someone's engaged in struggles for protecting the different life worlds of people, taking a political ontological approach is more prudent because of epistemology's risk of being distorted into just different perspectives. And so quickly, like, what is ontology? It's often described like in three ways. Like, one is assumptions about what exists. Two, it's how humans and non-humans interact with the conditions around them to produce multiple worlds or the act of worlding. And then three, it's kind of the narratives and myths told about the world that affect both what we assume exists and how we interact with the world around us. And so the approach, the political ontology approach is really like a modality of critique that looks at this process of reality making, including its own reality making. It's not trying to kind of uncover or analyze a different type of reality. It's just looking at the process through which different worlds emerge, and especially kind of in the face of a universalizing force of a modern ontology. As to whether other movements, schools of thought, struggles could use it, I definitely think so. I think like part of monopolizing world ontology and the idea of the universal and the neutral is, for example, if you take feminism, a very masculine idea of the rational and the universal. And so I think anyone whose grievances or whose struggle has been dismissed for not being based in reality is essentially facing an ontological struggle where their understanding of what the world is and what the problem is being reduced to essentially this perspective on the world, whereas certain people hold monopoly over what the world is. And so I think that approach can be used by anyone who is fighting to sustain to sustain their understanding of what it is that needs to be protected. Because if you can't have that, then it's obviously never going to be protected in the way that you need. I don't know if that's clear, but it's the best I can do in this short time.
Thanks very much, Nicola. Do we have any final questions for our speakers, or comments, or one speaker asking another speaker a question, or anything else before we close? I mean, we didn't hear that much per se on the idea of social justice. I mean, do the three of you feel that concept can speak to all of your, I mean, we did more from Nicola, but do you think that concept speaks to your work? Is it a useful lens through which to think about these various topics that you've discussed, for example? I mean, often it's just such a broad term, it might not necessarily mean very much to people. Or any final comments or thoughts? Tilmann?
Yeah, well, social justice, you rightly call it a contested concept. Many people understand different things on it. And in the paper that is underlying this talk, I try to dissect different approaches to social justice over the centuries. I always find this very useful if you have these broad concepts to look into the history of ideas, and from there bridge it into law again. And I think bottom line is that social justice, if you wanted to have it the easy way, it has at least two dimensions. And one is this, freedom from want, the protection against at least excessive forms of poverty. And the other dimension is the one that I was interested in, which is socioeconomic inequality or equality. And you can see that international law has addressed the first dimension quite for a long time, actually. So protection from excessive poverty has been on the international agenda for a long time, much longer than socioeconomic inequality. And you can trace it back all the way to the ancient Greeks, distributive justice, and you can look into what Aristotle has said on this, Cicero. Interesting stuff. And interestingly enough, some courts rely on these old writings in order to push their understanding of social justice. That's, I think, highly fascinating from my perspective, at least. So the contested concept, at least two dimensions, and one of them is socioeconomic inequality.
I just will compliment I think it's really hard to think about social justice or any human rights from your desk or from your library. I think we need to engage with people, outside academia and outside our circles. The global south, those that experience social injustice. So it's not just a doctrinal thing. We're talking about lives. We're talking about, I lost many people in this pandemic. It's just, it's real stories. We talk about human rights, but we talk about, people and things are happening. And it's I think it's cognitively impossible to imagine social justice from, our own experience. So we have to broaden. And then we have to accept there are good things going on in law abroad, outside our circles. We might not be aware, but there are things going on. So in the beginning of the pandemic, there are good experience in public health interventions in Asia, in the global south, but that was often ignored. So if you want to do social justice, and if you want to really, you got to involve these people, because they don't know you, and you don't know them as well. So that much you can learn with each other. And I think every time we talk about social justice, we have to be more inclusive. That's include academia as well.
Thank you very much. Nicola, would you like to say anything before we close? Okay, well, sorry, you trying to, no, okay. Well, I just wanted to thank all of our speakers. Thank you very much. I really enjoyed this panel. I think we all did. It was, I think there were a lot of synergies, but also a lot of depth to each of the separate papers. Thanks very much for everyone who attended. I can see some applause, so thanks very much. So now there is a short break, and then there will be panels on international investment law following on from Nicola, as well as a panel on water rights. So hopefully a lot of you will be able to join that. Thanks very much to everyone. Thanks to our speakers. Bye. Bye.